Could you use $2,000 right now? Well, listen closely because I'm going to tell you how to get it. In this video, you'll learn how you can get paid a $2,000 advance in your Florida workers' compensation case, even if it's denied and without settling. How's it going? Domenic Celeste, the virtual accident attorney here, and I'm back with another video. For those that don't know, I represent people injured on the job in workers' compensation and due to the fault of another in personal injury all throughout Florida. Now, as usual, before we get started, I have to show you this disclaimer, so just hold tight. And with that out of the way, let's get into the video. In a Florida workers' compensation case, there's potential for you to get $2,000 now, whether your case is accepted or denied, and without settling it. This is called an advance payment, which is found in Florida Statute 440.20. Basically, it's where you can receive $2,000 as an advance payment on your future work comp checks. But getting this $2,000 isn't automatic. There's certain things that you need to prove in order to get it. So let's go through what's required for you to get a $2,000 advance, as well as some helpful trial tips at the end, because to get this money, you usually have to go to court for it. But before we get into what you need to prove, you need to know how it is you can even ask for an advance. Sure, you can just ask the adjuster, but that usually isn't enough. Most commonly, a motion for advance is filed with the court with all of your supporting evidence, whereby you ask the judge to either award you the advance or, in the alternative, set an evidentiary hearing on it. However, in my experience, the judge usually doesn't just grant an advance without an evidentiary hearing. So now that you know the mechanism to apply for an advance, let's go through all the requirements that you need to get it. Firstly, you need to show that you either have not returned to employment at no substantial wage reduction, suffered a substantial loss of earning capacity, or have an actual or apparent impairment. Basically, you need to show that because of your work comp injury, you've lost wages whether you return to work or not, or that you have a physical impairment. Now, how do you show that you have an actual or apparent impairment? To show that you have an actual impairment, you need medical evidence from your doctor that you have a permanent impairment rating to your body as a whole, which usually only comes once you're at max medical improvement, or MMI. MMI means basically that you're as good as you're going to get medically. To show that you have an apparent impairment, say that 10 times fast, you need medical evidence from your doctor that you were prescribed a device to wear or use, such as a brace or crutches, and you wear or use that device, hence it's apparent that you have an injury just by looking at you. What about how you show that you have a substantial loss of earnings? Basically, you need to show that you're on at least work restrictions and that you've made less money after your work accident than before. If you're not making any money now and are on work restrictions, you should meet this requirement easily. Now, how much is considered substantial hasn't really been tested in the courts, but in my experience, if it's not enough to afford your bills, then your wage loss is probably going to be considered substantial. And how you show this wage loss is by providing documentation or testimony as to how much you were making before the accident and then how much you're making after the accident. And this is usually shown through pay stubs. The next thing that you need to show is that the principal purpose for the advance is either medical or financial, which basically means, why do you need it? The only way that I've seen an advance requested for medical reasons is to pay to hire an expert. But this is something that your attorney should be doing, not you. Remember, this is money paid now from what you may get in lost wages in the future. The main reason an advance is requested is for financial reasons. And most of my clients ask for an advance because they don't want to fall behind on their bills, which is reasonable to ask. But unfortunately, it's not going to cut it. To get an advance, you must have already fallen behind on those bills or borrowed money that you owe back so that you didn't fall behind. And this amount should be $2,000 or more. The most common way to show a financial need for an advance is to show how much your bills are every month and how many months behind you are on those bills. And how do you prove this? Well, you can just testify to what your bills are now and how much you're behind. There's no requirement to show documentation for your bills, even though some judges ask for it. If you did have to show documentation, it would be so expensive that it wouldn't be worth it to ask for the advance. Testimony, if credible and truthful, is more than enough, especially when there's nothing to contradict it. Another way is to show that you've borrowed money from family or friends or even loan companies. I even use credit card payments here, which are basically loans with interest, to show this as well. And how do you prove this? Again, you can just testify to how much money you've borrowed, from whom, and that it was used to pay your bills. But make sure to say that the money is expected to be paid back, which shows you still owe that money. Also, if you're not far enough behind on your bills or haven't borrowed enough money to individually hit the $2,000, then you can combine the two to hit the $2,000 threshold. For example, if you're behind $1,000 and borrowed $1,000, then you can add them together to get to the $2,000 threshold. Another important thing to note here is you must have fallen behind on your bills or borrowed the money to pay your bills after your work accident, not before, because there has to be some sort of nexus to your accident. I always have my clients testify that they weren't behind, nor did they borrow any money before the accident to meet this requirement. The next thing that you need to show, which seems kind of obvious, is that the advance is in your best interest, which is as easy as testifying that you believe it's in your best interest. The next thing to show is why $2,000 as opposed to something less should be paid to you. If you're behind on or owe $2,000 or more in total, then that's why you should get the full $2,000. However, if you're only behind or owe, for example, $1,000, then that's most likely the most you can get. By the way, it's possible to get more than $2,000 as an advance, but I never recommend doing that because then you have to show that work comp isn't prejudiced by paying it. And almost every time I've seen someone ask for $2,000, the judge finds that work comp's prejudiced and denies it. And guess what happens after that? The client doesn't get anything, not even $2,000, which is not only a complete waste of time and money, but also hurts you because now you're without any money to help catch back up on those bills. Something else you need to know is that an advance isn't free money. Even though you'll be paid the advance in a lump sum, the work comp carrier is entitled to deduct 25% of your future work comp checks until the full advance is paid back. Also, if you ever settle your case and haven't paid the advance back yet, the work comp carrier will most likely want to reduce your settlement by how much of the advance you still owe. For me, I always negotiate the settlement so that work comp doesn't recoup the $2,000 advance, which is extra money in my client's pocket. Now here are some bonus trial tips that I think you should know. Firstly, as I stated earlier, you don't need documentation such as bills or even your medical records to win in advance. If you're truthful and credible, then your testimony alone should be enough. However, this is where having an attorney is really important because you need to be prepared as to not only what to say, but how to say it, so you don't get objections like hearsay. But remember, this is an evidentiary hearing, so work comp needs to produce some sort of evidence to contradict what you say. So it's also important to try and get anything they have out of evidence. Probably the most important tip is that the advance hearing only relates to the elements to prove entitlement to the advance. What I've seen the work comp attorney do is try and confuse the judge by bringing in other stuff into the hearing, such as that your injury is pre-existing, some sort of fraud denial, or something else totally irrelevant to obtaining an advance. If they try and do this, you need to object to it being outside of the scope of an advance hearing because it's essentially causing a mini trial. So in summary, you should only go for $2,000 advance and not more. It should be requested by motion. You don't need documentation to support your request if you're credible. You need to have made less money after your accident than before, or have an impairment rating, or wearing something that shows you're injured like a brace. It must be for a medical or financial purpose, which means you're behind on bills or owe loans totaling $2,000 or more. You need to say it's in your best interest and why $2,000 as opposed to something less should be paid. And there you have it. Now you know what you need to do to prove your entitlement to and payment of a $2,000 advance in your Florida workers' compensation case. If you or someone you know were injured on the job or due to the fault of another, you need to hire an attorney. Give me a call any time of the day or night. I have a 24/7, 365 receptionist, or better yet, you can just text me, 561-935-3822. But that's it for this video. If you got value out of it or if you learned something, please hit that like and subscribe button. To learn more, watch my previous video here or watch a video I've chosen for you here. Again, I'm Domenic Celeste, the virtual accident attorney. Thanks for watching, and I'll see you in the next video.